శ్రీ లక్ష్మీ నరసింహస్వామి జ్యోతిష్యాలయం. కుటుంబంలో ఏ సమస్యకైనా 100% పరిష్కారం. విచ్చేయండి. సికింద్రాబాద్ రైల్వే స్టేషన్ దగ్గర రెతిఫైల్ బస్ స్టాండ్ ఎదురుగా, సికింద్రాబాద్. సెల్ 9849783528.
Good evening. Every Tuesday we do bring in immigration updates from 5 p.m. to 6 p.m. Central Time. Along with me is my business partner, Emily. Emily, what do we have today to discuss?
Yeah, today the ICE director held a press conference and they claimed that their investigations uncovered 10,000 plus F1 students who are engaged in some sort of fraudulent activity, particularly OPT and STEM OPT holders. So we'll talk about what exactly they're alleging there and how it could impact students going forward. Also on the F1 front, we are expecting the duration of status regulation that cuts short the F1 program to come out soon. So we'll talk about what you need to know about that, how it's going to impact it, and how is that related to this announcement today about this 10,000 F1 student fraud situation. And then we'll kind of compare and contrast what things we saw during the first round of the Trump administration when it comes to H1Bs and what we're seeing now in round two. What's changed? How are they going about restricting H1Bs this time around? Lastly, FDNS, the Fraud Detection National Security Directorate. These are the officers that conduct site visits, particularly for H1B employers and their employees. So what are these officers really looking for during a site visit, and how should you prepare?
Emily, the first thing, the 10,000 people, that amounts to almost like about less than 0.3% of the F1 population that they're speaking about. So the OPT and STEM extension violations, what they're telling is that some of the people are not working, but they're pretending to be working. Some of the allegations that they've said is that these people will be, they're outsourcing the HR activity to India, that it's outsourcing the supervision activity to India or some other country. So their theory is that if these people are getting supervised in India and they're working and getting supervised in India, how come these people are getting the OPT here? The only reason why they're getting OPT is to learn the things here in the United States, and so that they can go back to their home country so that they can perform better. What are the other allegations they said in the press conference, Emily?
Yeah, so they're claiming that there were coordinated fraud schemes involving shell companies sharing websites, management personnel, and job postings, students allegedly being farmed out to undisclosed third-party work sites. They even mentioned potential international financial fraud with money transfers and so-called phantom employees who obtained OPT authorization but never actually showed up at their work site. And this was based on investigations conducted in Texas, Virginia, Georgia, Illinois, New York, New Jersey, North Carolina, and Florida.
They also alleged that some of the companies have taken the money to give them the employment authorization to the employees, either giving the STEM extension or probably maintaining them on the OPT. That's the allegation that they made. Emily, and then the second topic that we're discussing is the F1 regulations, which we're going to combine into the same talk, is that the administration is going to, they did issue a notification last week that they are coming with new regulations with regards to the duration of status of the F1. That means a person who comes into the United States on F1 can stay in the United States, can change the colleges in the United States without going to the USCIS, can apply for the OPT and STEM extension without applying for the extension of the I-94. They want to restrict the F1 visa for 4 years. That means that I-94 expires in 4 years. Now, normally, if they have a bachelor's degree, their F1 expires in 4 years. And they haven't yet said when it comes to the master's degree, they're going to give it for 2 years, 4 years, very clearly, though. But it seems that if people want to extend their stay in the United States, they not only have to file for the OPT and STEM extension, but they may have to file an I-539 form, Emily. That looks to be a very lengthy process for them to apply. I mean, is this press conference anyway related with that, Emily?
They did not specifically say that, but I mean, the way the timing of it is very suspect to me, because in the proposed regulation, they said they were wanting to make these changes because they felt that they needed to increase their fraud prevention and national security measures. And so, of course, right before they're ready to publish this final regulation, they're going to come out and claim that there's all of this fraud running rampant in our student visa category, and therefore this is why we are publishing this regulation to restrict student visas. So they're going to restrict you to only giving you a time to complete your particular program. If you want to change your program, if you want to extend your program, do anything other than what you were initially admitted to the US for, it's not just getting permission from your school anymore. Now you've got to get permission from USCIS. Same thing when it's time to apply for your OPT and then again for your STEM extension. I expect USCIS is going to be looking at more closely, have you properly maintained your status? Are you still actually a student? Have you been in the US for an extended period of time? And they may use those things to deny your extension and deny your OPT and your STEM extension. So I think overall, we're going to, be restricted on changing programs, changing majors, staying in the F1 status for many years. You're not going to be able to transfer between schools. You're not going to be able to continue and do like a second master's. This is definitely targeted towards these day one CPT programs that students use if they didn't get selected in the H1B lottery. So you can expect more filing fees because you're going to be filing I-539s every couple of years, more biometrics, longer processing times, greater risk from these delays. What happens if you don't get your approval in time and your I-94 expires? What happens if you don't get your I-94 extended and your OPT is still pending? And then, of course, without having that duration of status, there's a consequence now if you overstay. You will be accruing unlawful presence, which generally is not the case for F1 students.
This is a very huge change for the student visa people, Emily. In the past 3 decades, this is the most significant change what I've seen, and the students yet don't know what is coming up front them, though. And also, there are already 11 million pending cases with the immigration. They couldn't handle the 450,000 new applications that are coming into this one. And if this is going to increase the paperwork, for example, everybody has to file an I-539 to extend their status, it's going to be a humongous backlog. And there may be a lot of people who may not get their work permit on time. They may have to, or STEM extension on time, Emily. There's going to be huge backlog that may be popping up in the USCIS.
Yeah, and I think they're really going to be scrutinizing those STEM applications to make sure that the employer actually qualifies. I have a feeling they're going to be really focusing on these third-party placements and trying to claim that there's not enough supervision happening there, and really looking into the employer a whole lot more, because generally when you file your STEM extension, you get permission from the school. That's through the 983 training plan, which is reviewed by the school. You don't normally submit that to USCIS unless they specifically ask for it. So there's no real looking into the employer. When you file an I-765, you only mention the employer to provide their E-Verify account number on if you're applying for a STEM extension. But even for initial OPT, you don't have to specify anything about the employer. So I have a feeling all of that is about to change, because supposedly 10,000 students, 0.33% were found to have, potentially be doing fraudulent activities, which they should certainly be going after those things. I'm not against that at all. Get rid of the fraud, 100%, no problem with that. But don't impact the several 100,000 other people who are following the rules and doing everything correctly.
And Emily, when do you expect these regulations to go through?
I mean, they're already with the OMB, which means that they're just getting final approval before they get published. So it could literally be within the next couple of weeks, especially with this press conference today. I think they're laying the groundwork for it. So it could be any day now. And it'll take effect usually 60 days after they announce it.
And some of these regulations may be affecting the current students, not just the future students, though. So we may be expecting even the current students who are going to be applying for the OPT may have to go through the I-539 form. We are yet to know that, whether they're going to apply going forward, whoever got the student visa, or whether they're going to apply for those people who are already, who are existing people or the new people. We have yet to see that, Emily.
Yeah.
With Emily, Trump was there before between 2016 and 2020. We have seen that. You have been a lawyer, I've been a lawyer. And now, from now onwards, 2020, from now 2025 onwards, what are the different changes you have seen compared to what Trump was before on H1Bs?
Yeah. Specifically for H1Bs, prior Trump was a lot more difficult in the adjudication of those applications. That time we were seeing the most denials we've ever seen of extensions, people that were already approved, because they eliminated that deference policy saying we don't have to defer to a prior approval anymore. We're going to look at every single petition with fresh eyes. That's not the case with this Trump administration, though. Also, the prior Trump administration was really looking at wage level 1. So if you were using the entry level prevailing wage, you were getting requests for evidence asking, is this truly a specialty occupation, or questioning whether the job duties were actually more complex than a wage level 1. We also back then had the employer-employee relationship issue, which particularly impacted third-party placement consulting staffing companies, end client letters being required, contracts, MSA, work orders, all of that. A lot of questioning specialty occupation. Does the job actually require a bachelor's degree in a specific field of study? And then visa stamping delays and denials. So that's kind of how the previous Trump administration operated to limit H1B. This is now a whole new ballgame. Number one biggest thing is $100,000 to block every H1B who's outside the country. I mean, that cuts out so many petitions from being able to be filed. And then this time around, they're revoking visas for any law enforcement interaction with no warning. They're even revoking the visas of family members on H4 that didn't do anything wrong. Now they're scrutinizing more heavily. Did you maintain your status properly during your previous approval? So if you're filing an extension, you're filing an amendment, you're filing a transfer, if you have any issues with your paychecks not being correct, working in the wrong location, anything like that, they are finding that, they're denying and saying, now you need to pay the $100,000 fee. Most recently, we have the change in the I-129 form, where now they're going to use these questions to determine has the employer selected the correct wage level on the LCA. We're starting to see RFEs, notice of intent to deny, on that issue already for those employers that maybe did not select the correct wage level. And then we know it's coming is going to be the change in how they calculate prevailing wages. Of course, it's going to be increased prevailing wages. Expecting that new regulation to be coming out in the near future as well. And we're only just getting started. I think there's plenty more coming from the Trump administration when it comes to H1Bs. We still have 3.5 years left.
Yeah, we're still yet there. It's a nightmare, Emily. I wanted, what FTN is visiting a lot more than previously, Emily, as you pointed out. What are they looking when they are coming into? Let's say I'm working for a consulting company, I'm working with an end client, I'm working from the home. What should I be prepared for?
Yeah, I think they are initially trying to determine, does the company exist? Does the worker actually exist? Does the job actually exist? Beyond that, they're trying to verify what was said in the petition versus what's actually happening. Are you doing the job that you were supposed to be doing, where you're supposed to be doing it? Are you getting paid what you're supposed to be paid? So I think those are really the main things that they're trying to determine. And then they're going back and revoking or sending notice of intent to revoke whenever they find that what you said in the petition is not actually accurate.
And Emily, do I need to show them the pay stubs? Do I need to show them the W-2 forms? And sometimes they ask questions with regards to how many employees my company has it, what all they're doing. Do I need to answer them? Or what if I don't know the answers?
Yeah, I mean, if you don't know, obviously that's okay to say you don't know, but there are certain things about an employer that you likely would know if you are working for that employer in the job that you're saying that you are doing. And since January 2025, it is mandatory for you to partake in the site visit. So yeah, they are generally asking to see your pay stubs, asking to see your W-2s, asking to see your workstation. Sometimes you even see some work product to verify what you're actually doing. And they can ask a lot of questions. A lot of times now they're asking, how did you get the job? Who interviewed you? Who do you report to at the company? Because they want to know who all the players are within these companies, and using their AI, they can connect the dots between companies that may be collaborating with each other, companies that are, sharing resources and that sort of thing. And that raises a red flag in their mind, especially given what they're claiming are fraudulent activities for employers of OPT. They're saying companies sharing websites, sharing management personnel, using the same job postings, farming people out to undisclosed third-party work sites. Those are all these ghost offices. They all are looking at those as fraudulent, whether they're legal or not. They're assuming that they're fraudulent. And so I think that's what they're looking for more, especially with all the social media talk going on. Every day on Twitter, there's some new video of them storming some company that's empty because they don't have workers there, claiming it's a ghost office or they're ghost jobs, but they're taking American jobs, but they're not real jobs. So I'm not really sure what they're just mad at everybody. But H1Bs are the ones that are is being taken out on, unfortunately.
Anything else, Emily, before we go to questions?
I think we can move on.
Rachan is asking this question. Does a site visit happen regularly? Yes, it does happen very regularly. It's happening more regularly than previously. What I want you guys to prepare is to have your friend pretend like an officer. Let him come to you and let him ask the questions so that there will be a interview done by him. Of course, he won't be any harmful guy to you. It's better to be having a friend answer the question to see where you started. Of course, you don't have to show your pay stubs to your friend, but of course, be prepared to show the things. You have to be prepared to show for the evidence. It's always good to have that one. Have a cousin do that. It's called a mock interview that I call it as. And you do it for your cousin too. That way that you are prepared for it though. It is happening very frequently. We see a lot of trouble for it. Especially for those people who are, you have to be working at the location where you are at. That's where we get into trouble. Oh, I am working remotely. I was working in New Jersey. Now I'm working in Dallas. How does the government care? Because I'm working remotely. Anyway, they do care. Because if you were to work in New Jersey, now you're working in Dallas, you did violated the H1B. The company is supposed to file an H1B amendment before you move, not after you move. So please, changing the location is very dangerous.
Nirvana says, I recently got my green card. Do I need to get my social security card amended? What all the other things do I need to get updated? So you don't need to, as in it's not mandatory, but I do recommend it because previously, especially during COVID times, when people were losing their jobs, getting new jobs very quickly in a short period of time, if you still had that social security notation on your card saying that it's not valid without DHS authorization, and you lost your green card or your green card expired and you've applied for a new one, they were taking 2 years to give you your new green card. And that's the only document that you have to prove that you don't need anything else to use that social security number. And so people were not able to start their new jobs because of it. So ever since then, I've said, yeah, go ahead and get it updated to take that notation off. That way you can use your social security card and your driver's license instead of your green card in case you're ever stuck without your green card or delayed in getting that replaced.
Emily, I have a very good question from Abhilash Chowdhury 7664 from YouTube. And I want you to correct me because I'm going to answer the question, but I'm not. I want to be 100% correct in this one. What is considered to be interaction where you have to mention it in the forms of DS 160 form or 485 form or I-539 form or inform the immigration lawyer? What is considered to be interaction with the police? That is the question. He's saying that somebody bumped into his car, so he called the police. Is it considered to be interaction? Does he need to inform the DS 160 form? Does he need to inform immigration lawyer? Does he need to inform the 485? Does he need to inform the H1B lawyer? Does he need to inform the I-539? In this case, he doesn't need to inform because he was not being arrested. He was not being charged with any crime. I'm assuming that he was not being charged with any crime. Now, if it's a regular traffic ticket, which involves which involves less than $500, and you took care of it. You took care of means either you paid the money or you challenged it in the court and got the case dismissed. You do not have to report it. Now, if they have detained you for whatever reasons it may be, then they doubted that you don't have a driving license, they detained you, or they detained you, or they said to you that you are under detention right now, even though they did not put a handcuffs for you. That will be considered even if they don't put the handcuffs for you. If they say they are detained, you are considered to be detained. But if it's just a regular traffic ticket, they just gave you the ticket. It's under $500. It's not considered to be a detention. It's not considered to be an arrest. You don't have to report it. Correct me, Emily.
Yeah, absolutely. But the crazy thing is, when you're filing something with USCIS, like an I-129, an I-539, an I-140, an I-765, then we're getting these RFEs saying, we see you had some sort of law enforcement interaction, you need to go for biometrics. And then they send another RFE saying that we need to know what happened, depending on what exactly came up. And that's happening for victims of crime, that's happening for more traffic related issues. So although you don't need to disclose any of those things Rahul said, they may still question you and come up through a biometrics RFE or even an RFE after the biometrics to confirm that there was no actual conviction or no arrest or no detention.
In this case of the interaction where you called on the police, though, there must have been some insurance that you may have given and some documentation from the insurance company, though. Please keep the documentation. If you have paid the traffic ticket, please make sure that you keep a record of that one. If you have got the case dismissed for the traffic, please keep a record of that one. It's always good to keep a record of those things. Especially going forward, don't panic if you don't have a traffic ticket that you have not got 10 years ago, you don't have a record, don't panic for that. But going forward, please keep it for our sake. It will be very good for you.
Bharat says, my STEM OPT ends on May 14th, 2026. So that's 2 days from now. My employer filed my H1B and premium processing, sent it to USCIS on Monday. I did not receive my receipt. I only have 2 days left until my EAD ends. What do I do now? So you will be eligible for the cap gap, assuming that this was filed as a change of status to H1B. The problem is you won't have documentation that you qualify for it until you actually get that receipt notice. So your employer may tell you that because you don't have the I-9 documents needed to re-verify your I-9, that they're going to have to terminate you or you're going to have to stop working until your receipt notice comes in. Then they'll be able to complete the I-9 properly using your expired EAD card plus the receipt notice for your I-129 H1B petition.
I had a traffic citation, but I have a traffic citation for not reporting an accident. This case was dismissed before the Kate due to the pretrial diversion. No arrest was made. Should I disclose this on the I-160? Absolutely, you need to. This is if you had a traffic accident, you did not disclose it. It definitely is a major issue. This is not a minor issue. You should disclose it.
Pranav says, my H1B extension status is pending in premium processing. Is it okay to start my parental leave, or do I need to wait until the approval comes through? So I'm assuming this is some sort of family leave that your employer provides as part of the usual company benefits that anyone at that company would receive, and that you would have documentation of it. So yeah, you could start that process. The pending extension does not make any difference whatsoever for that. If you qualify for it and you keep the documentation of it and it's part of the employer's approved leave, you can do that.
How does the site visit work when there are multiple locations listed on the LCA? They could go to the end client. They can even go to your company location too, even though it's not listed in the LCA. For example, a consulting company location may not be listed in the LCA because they can go to there. And if your home address is listed, they can even come to your home too. Assuming even it's only company address, end client address, they may still come to your home because they know your home address though, because they will have the I-129 form with them. They can still come into the home. So they will come and visit. They will have one thing with them. They will have the H1B petition. They will have the LCA. So it's better that you have that with you. So you take a look into it. You're spending this much time with us. Spend 10 more minutes. Look into the H1B petition. Look into what the employer has stored. Look into what the LCA salary is. And if there is any discrepancies, contact your employer lawyer. That's a nice guy for you to deal with rather than dealing with the immigration.
Jolly Mail says the H1B grace period is ending on May 15th, 3 days left. An H1B transfer was already filed and in regular processing, but no receipt notice yet. Is it legal to stay in the US? So assuming that it's properly filed and a receipt notice is actually issued with a received date prior to May 15th, yes, you are legally allowed to stay in the country. You're in a period of authorized stay based on that pending H1B extension or transfer application. The risk is if your H1B for some reason gets rejected and your grace period has already ended, when they turn around and refile it after rejection, you're going to get a later receipt date, which is going to be outside your 60-day grace period. That's where the problem is. So although, yes, it is legal to say, assuming everything's fine with the petition, it's, a little bit scary to wait not having that receipt yet.
Hari Singh from YouTube has this question. We received EB-based green card. We booked our tickets via Abu Dhabi to India. Do we need to carry additional documents other than GCN passport? No, you don't need to carry an additional documents other than GCN passport. Because you're a green card holder, I'm okay for you to travel through Abu Dhabi. Now, if any non-immigrant visa people will call me and ask me, I'm traveling to Abu Dhabi, my recommendation is do not do it. First of all, we are just telling everybody not to travel. And if you were to travel, Abu Dhabi is the worst thing. But since you have a green card, I don't feel any problem for you to travel. And your green card and passports are the only thing that you need for you to travel.
Pappy says, physician from a 39 country country filed EB2 perm I-140 and premium processing last January, still not adjudicated. What can I do to move the case forward? Litigation. It is working. And that's the only thing that's working. I know they're claiming that the ban has been lifted for physicians. We're not seeing that happening yet in practice. So you can either wait it out or litigate.
Question from Market Update. He is an H1B. He has got an EAD based on the EB5 and advanced parole. Can he use a EAD in advanced parole and then he can come back to H1B later on? The answer is no. The reason is that if you want to come back from EAD to H1B though, You have to get a H1B approval, and then you have to go to your home country to get the stamping. There are multiple problems for it because the company has to pay $100,000 fees. So practically, the answer is no. You can't come back to H1B because most companies, 95% of the companies, are not willing to pay the $100,000 fees.
Aranon has a good question. If the government does lift this USCIS pause for medical physicians, how would it identify medical related applications? Do doctors have a separate form besides the 765 or 485? No, I mean, the only form that they would do differently is the physician NIW, I suppose, but even that form is just the basic I-140. I don't think they have a way to like run a report of all applications we have pending to see which one is for a physician. They're going to have to create some sort of process for that, and I can guarantee you it's going to be an inefficient process and take forever. So yeah, I don't think that is really going to be truly lifted in the very near future. They're going to take their sweet time.
Does a spouse has to wait for 5 years to receive citizenship after her spouse got the citizenship? Assuming you are already a green card holder, if your spouse is a U.S. citizen, the waiting period is only 3 years. It's not 5 years, though. There is an exception that it's only 3 years that is required for you if you are married to a U.S. citizen.
Krishna says, is the H-1B wage level increase only for the entry level, level 1, or is it all wage levels? And will the current amendment or extensions be affected with this increase? It's for all 4 wage levels. So basically they take the whole bell curve and move it over, increase it. Every single wage level will be higher. If you are not filing anything right now, it does not impact you. Your current wage stays the same for the entire time of your current approval notice. But when it's time for you to file your next extension or you need to file your next amendment, if the new wage levels are in place, then yes, you will be affected at that time.
Would the 100K rule apply if I'm applying H1B in consular processing this year? I'm an F1 in USA. First of all, if you're an F1 USA, why are you applying in the consular processing? You should not apply in consular processing. Second, if you do apply, yes, the $100,000 is applicable for you.
Smith Shaw says, I recently filed this I-751 for removal of the conditions on my green card. Do you think the approval timeline will be impacted because of strict vetting processes? Yes, we definitely saw that during the previous Trump administration. I think at one point the processing time was almost 4 years for the I-751 removal of conditions. So they had to issue new receipt notices for everyone, extending your green card for 4 years. So they could take their time with that process. So I would expect more of the same on that.
There are a lot of queries coming with regards to whether I should report or not. One thing is that if it's anything traffic related less than $500 just to traffic, then it's a different issue. But if it's anything else, guys, I want you to have a private consultation with a lawyer. One problem that I notice is that the criminal lawyer tells you not to report. No, don't listen to the criminal lawyer, only listen to the immigration lawyers because it's a different thing. Oh, my case has been dismissed. Well, why is your case dismissed? You may be on probation. You may have a pretrial diversion. There are a lot of different things that can happen. Let's say you have been arrested for DUI. It can be a pretrial diversion. It could be a 1-year probation, and the case will be dismissed. You have to report that one, though. You have to report that one. So it's very important that why the case has been dismissed. Once you've been charged with a crime, even if it's been dismissed, you are supposed to list that one in there. That is a major problem. In fact, we are getting some 485 denials because of misrepresentation because you never informed the immigration properly. We have also had some misrepresentation because people did not inform in the DS-160 when they filed for their H-1B extension or H-4 stamping when they're coming into United States or when they're getting their stamping extended. So it's very important for you to learn. Now, if you have any doubt, though, it's always good to list it. It may create some minor problem for you, but it will not have a long-term problem if you have any doubt. Now, I've had one person today, Emily, where the person filed a 485. I filed his for 485. And I asked him, do you have any crime? He says, no, I don't have any crime. But I have a DUI that was dismissed. My lawyer told me not to tell anybody. I said, I can't. I mean, his 485 will be denied. I mean, I don't know what to do.
It's already filed.
It's already filed. And he's
Right.
been called for the interview. So I was like, wow. Why did not you tell me? I thought that since the case is dismissed, I don't have to inform. This is what my criminal lawyer says. No, don't follow your criminal lawyer direction. Follow the immigration lawyer's direction when it comes to the immigration. Now, when you go to the criminal courts, you can follow what he wants to say. But when you come to the immigration, you follow the immigration lawyers, not your criminal lawyer's thing.
Wanderer Travel says, I'm on H1B in my 6th year. My perm was denied. The 7th year extension is pending. The employer is pursuing an appeal and a new perm. Spouse has approved I-140. Can I apply for the H4 EAD? Must I stop working until I get that EAD? So if your 7th year extension is pending, and your 6th year has already expired, you need to get that 7th year extension approved before you can file for an H4 and H4 EAD. Otherwise, you need to exit the US, go for H4 stamping, come in on H4, not work until you get the EAD. If the 7th year extension is pending and the employer does file an appeal, you can still get the 7th year approved. And then once you have that approval, you can apply for the change of status to H4 and H4 EAD and work while that's pending until you hit year 7 or until your H4 gets approved without an EAD, then you'd have to stop working. So just because you file the H4 doesn't mean you have to stop working. Depends on whether you still have a valid H1B to continue working on. But if the H4 gets approved without the EAD, that's where the gap is going to be in your employment authorization.
Karan and a lot of other people are asking this question. If it's a simple speeding ticket, which involves less than $500, no arrest involved in it, you don't have to report, guys. Now, if your immigration lawyer is telling you to report it, it's up to him. Though we tell not to report, we have no issues with that.
Vivek says, I applied for a change of status from H1 to H4 and H4 EAD in December 2025. Standalone. What are my options to get the results in the EAD? Litigation. Otherwise, you're waiting until your case is considered to be outside the normal processing time, but they keep pushing that date back. So you can never submit a service request. Not working, going to any kind of congressional liaison or ombudsman office. Litigation is really the only thing that's working.
Shivaya Amin has his question. His H1B expired in 2020, and after that he left the country. He only used up 2 years of the H1B. He still have the 4 years left. Now he's visiting United States on a B2 visa. Can he transfer from B2 to H1B without subject to the lottery and without subject to $100,000 fees? The answer is yes to both the things. Since you already been counted the H1B number, you haven't used up the 6 years of H1B, you can transfer your H1B since you are in the country in a B2 visa. And since you are inside United States, the $100,000 is not applicable. Since you're already counted toward the lottery, you don't have to go through the lottery system. Motion has an interesting question. I have a H1B. I have an I-140 approval. My wife has an H4 plus EAD. The employer, is it, why do my wife has to file an I-140? What benefit is that going to be? It may benefit. It does not harm you in any way. How it may benefit is, for example, if your wife gets an I-140 approval and maybe tomorrow she gets a H1B, and if you lose the job, we're going to move you to the H4 plus EAD. So right now, everything is dependent on you alone. Because if you lose the job, there is nothing there. Your wife have to stop working. You know that. But in case if your wife also get an I-140 approval and maybe later on she gets H1B, then what happens is that you may not be able to use a priority date to get the green card, but you may use it to get a H4 EAD. So it's definitely advisable for if both the couple are there, both get an I-140 approval, both should be counted toward the H1B. one person can want to stay on H4, but should be counted to the H1B, then later on stay on H4. In that way, you will be in a much better situation, because if your spouse loses a job, you can always get the H1B and have your spouse get the H4 plus EAD.
Nandini says, how can I file for an I-140 when I'm on H4? I've used up all 6 years' time on my previous H1B. I-140 doesn't ask for your immigration status. You don't have to be working for any company to have an I-140 filed on your behalf. You just need to have a job offer. Same thing with the labor certification. It's not required for you to be working for that company if they have a job offer and go through the labor certification process. So you can go through that entire green card process, get your I-140 approved, and then you could switch back to H1B and extend beyond the 6-year limit based on that I-140 approval.
Only question coming from Suri is asking this question. Midterms, we know that Trump is going to lose the House for sure, to a greater part of Senate and maybe even Senate too. What do you expect after the midterm? Trump is going to turn around and say immigration is great and he's going to promote immigration, or he's going to continue the path what he's doing right now?
I think number one, we may have opportunity for a lame duck session for Congress to finally get off its butt and do something. But number two, I don't think there's any changing the path that Trump is on. Stephen Miller made it very clear what he wanted from the beginning, and they're just getting started. I don't see any plans for them to reverse course, even if they lose an election.
What do you mean lame duck session? That we're going to get any positive things from lame duck session or negative things only?
Well, potentially, you have, if we get Democrats taking over and we have people leaving that no longer have constituents to worry about, they may be more willing to actually compromise and come up with an actual solution to our immigration problem that they've been kicking down the road since 1997. So it could be positive. It could be something for dreamers. It could be something related to the visa backlog and retrogression and the lack of green cards. But there also could be more enforcement coming along with it. It's, generally the idea has been some sort of comprehensive immigration reform during those times, which has never made it through, but you never know.
Okay. Bhuvan Srinivasan has this question. Can you elaborate on the adjustment of status self-employment? What we're speaking is that once the 485 has been filed, adjustment of status has been filed, after 6 months, you can leave and join a different company though. Is self-employment allowed? Absolutely, it is allowed. But I want to take it with a pinch of salt though. It will be scrutinized very much by the USCIS because they don't understand their own regulations. They don't read their own memos, which we can have them read it. But why I want you to be very careful. I want you to consult an immigration lawyer. I want you to be very careful. I want you to continuously run the payroll. Even though you're self-employed, you can do, it's like doing business as, I can go to Rahul Reddy, doing business as ABC, I can do that. And then I can draw a salary on myself. So you have to show the consistent employment in the same field where you are in. And I also want to have the salary running for you. I also want you to consult an immigration lawyer before you take up the self-employment. There is a memo from the USCIS that clearly says self-employment is allowed. That memo comes from the USCIS.
The Patel 9 says, being on an F1 visa, can the student be a co-founder in a new company and help them for marketing? Depends on whether you have employment authorization. Assuming you don't have OPT or STEM OPT or CPT, the answer is probably no. You're not authorized to work while you're on F1, even if you're volunteering. If it's something someone would normally be paid for and you're doing it for an actual company, no, that would not be allowed. Now, I think that's different than, maybe some friends getting together, doing a hobby, and you're just, having fun with that. And you're, I don't know, somehow marketing your hobby, but, and not trying to actually turn it into a company, but you would actually need OPT, STEM OPT, and it'd have to be related to your field of study. So I'm assuming you're a marketing major in order to be able to do something like that.
Is the green card process faster for an Indian citizen born in Singapore? Absolutely yes. You can consider yourself Singapore for the purpose of the green card in United States. Yeah, that is also applicable for the people who are born in UAE. They never had a citizenship or a green card or whatever you call there in those countries, but they always were an Indian citizen, but they were born in UAE. For the purpose, they can be categorized in the quota of the particular country that they are born in. So definitely. The people ask the question, hey, can I use that Singapore H1B? No, H1B1. No. For being using a non-immigrant visa like E2 visa or H1B1, which is different than H1B, you must hold a Singapore passport though. But for the purpose of the green card though, even though you never have a Singapore passport, you never are a citizen of Singapore, you will be considered under Singapore quota in the green card is way, 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 way faster.
Special case says, do we have to let the USCIS officer inside our house for a site visit? Maybe. I think that depends on whether your home is your work site, because a lot of times they do want to see your actual workstation and see that you're doing work. Now, if your work site is your office location and they just happen to come to your house, I think you can negotiate with them and say, can I meet you at the coffee shop down the street, or I can meet you at the office or something like that. But if that's your actual work site, they may want to see that.
V. Kumar has this question. My H1B picked out in 2025, processed before President's Procure, and it was done in consular processing. I'm currently an L1B. Now, can we change my petition from consular processing to change of status? What are the risks? You can change for consular processing to change of status right now. You will not be subject to the lottery. If the same company is filing for the change of status, you will not be subject to the $100,000 fees. And it is strongly advised that you do the change of status instead of going and getting the stamping. That is the best thing to do.
Satish says, is it advisable to file a nunc-pro-tunc request for a 26-day status gap that occurred in March? The H1B extension was timely filed, but the petition start date was mistakenly based on the prior I-797 expiration date instead of my shortened I-94 expiration date caused by the passport expiration. In our experience in this Trump administration, they do not approve nunc-pro-tunc requests in that situation. And when that nunc-pro-tunc request gets denied, you are now considered to be unlawfully present and you got a denial. That means they can issue an NTA. It's a huge risk. So I think it's important to look at your other options, which you may very well have, but the nunc-pro-tunc is not a great option.
Sandeep has this question. I'm born in India. I'm an Indian citizen. My wife is born in Thailand. Can I apply the 485 under the non-Indian quota? That's the rest of the world. Absolutely, yes. And people may ask question, wait a minute. He said the I-140 belongs to him, not to his wife. I heard it. It's called cross-chargeability. Even if your spouse is born in a different country, you can still apply for the adjustment of status based on your spouse, even though she's not the primary applicant. However, he has not a good question. My employer is not helping me to file the 485. Can I file the 485 by myself? The answer is, if it's an EB2 and EB3, definitely no. You cannot file the 485. Only your company can help you file the 485.
Nomad 10 says, I believe employment-based immigration like H1B, EB1, 2, and 3 are a small percentage of total immigration in the United States. Why are circumstances so against these legal immigrants? That's a great question, and that is entirely because Stephen Miller likes no immigrants. all of the campaign promises about going after the worst of the worst and getting rid of the undocumented population and stapling a green card to your master's degree diploma, that was all fake news. They don't like any immigrants, even the legal ones, even the high-skilled immigrants. They're all coming after our jobs. They're all taking all the housing. They're using our schools. They're using our healthcare. Stephen Miller, that's why.
Is NIW apply in EB2? Is it a good step to apply? Assuming that you have no I-140 approval, if you are eligible for NIW, definitely it's a good thing to apply. Why not? It's a good thing. If you already have an EB2 or EB3 approval, I am not sure if that's a good idea, but definitely it won't harm you in any way. It may help you, but it doesn't harm you in any way.
Ms. Dunn says, my priority date is March 2014. It's current. Followed your instruction by sending in the I-693 interfile 2 weeks ago. What else can I do to wake up my case? If you need to submit a supplement J, you could potentially do that. Otherwise, litigation is probably going to be your next best option.
Are marriage-based green cards currently affected by the bona fide marriage between Indian applicants and the US citizen? What is the timeline we're expecting? I have a very good news for this one, though. I normally screen my cases. I only take genuine cases. Of course, our office does only genuine cases. And my cases are flying through very good, absolutely not a problem marriage cases. No issues at all. I mean, absolutely. In fact, we're getting green card in 3 months for the marriage-based green card cases right now, which is a very good news, though. So even though there is a lot of things that are going on in the media, though, I don't see any problem with the marriage-based green cards at all. In fact, they are the smoothest thing that are going right now. Now, maybe some of the cases may have some marriage issues. There may or may not be genuine cases, but I screen my cases very good. I make sure they are genuinely married, and absolutely not a problem. Very fast green cards we're getting it.
Oscar says, asking for a friend, he is from Zimbabwe, completing his master's in May of 2026. The status of his OPT is pending. Those who completed in December 2025 are still waiting for the approval. Has USCIS stopped processing? Yes, they have. Zimbabwe is one of the 39 countries that are currently experiencing a adjudications pause or benefits pause from USCIS. They're taking your money and then not processing your case. And we don't know when it will end. People are litigating it. Litigation seems to be working, so that might be an option for your friend. Otherwise, you may need to consider re-enrolling in school, because that OPT, if it's not approved fast enough, might be useless by the time they actually get around to adjudicating.
K445 has this question. What is considered misrepresentation or fraud and employment-based green card? During the COVID, most of the green cards were approved without the underlying I-140. I don't think so. That is true at all. We can't even file a 485 application or the without the I-140. I don't know where that news is spreading around. I have never seen any approval. I never even heard of anybody getting the green card without the underlying the I-140. Now, of course, if they are marriage-based, they don't need an I-140. They need an I-130. But if it's an employment-based, I've never seen anybody getting it approved. So that definitely is a misinformation that you have. And this is the kind of information that is getting spread around. Who don't understand what an immigration is, who don't understand how the law works.
Admin says, does renewing a passport while an I-485 is pending require any formal update to USCIS? And can the old passport be used for an I-551 stamp? It does not require any formal update, but I'm pretty sure they will not allow you to use an expired passport to put a 551 stamp in the event that your green card is approved.
I'm an H1B visa approved, I-797 until October 2028. having I-94, I have no stamping. Can I travel to Canada or Mexico for 2 weeks vacation? We are advising not to unless there is any margarita switch or something that any mistake correction that you want to take care of it. We are advising people not to. This is coming from Vaishnav from YouTube. We are advising not to. I mean, take a vacation to within United States, Puerto Rico or Hawaii, maybe.
The Dananika says, I saw a lot of perm refusals based on G10, not enough information regarding education. Are those being successfully appealed? Seems like DOL suddenly changed their requirement on how much info they want. Yeah, so everyone's appealing them because you're right. I mean, they've only provided instructions in their form on saying how to fill out, and they said provide a brief explanation. Everybody's been providing a brief explanation ever since this form came out. Getting approvals, no problem. All of a sudden now the brief explanation is not good enough without them providing any update or instruction or advance warning. It's too soon for people to say that they've gotten approvals because the appeals processing time is about 6 months right now, and this is a relatively new thing. So no, I don't think people have been successful yet, but they should be, given the fact that they're filled out exactly how the form instructions say to fill it out.
I have a DUI and my wife is going for H4 stamping. Are you expecting any problem for the people who are going for H4 stamping? Yes. Especially if you have an arrest record and you don't have a stamping in the passport. And even if you have a stamping in the passport, they have revoked all the people's passport visa who have ever DUI. They are telling, hey, your husband doesn't have a visa stamping. Have him come into the consulate to get the visa stamping. And that's what they are telling. Now, that doesn't mean that you should go there, because if you go there, you're not coming back. So definitely anybody who has a DUI, and even if their spouse is going for stamping, we are seeing a lot of problem. But right now, since your wife is already outside the country, she doesn't have any option. She should take a chance and see how it goes out.
Satya says, I'm up for a promotion from analytics manager to director. Can an amendment still be filed using the same code of business intelligence SOC code with a higher wage level? Depends on the duties entirely. We have to look at what are all the job duties, what's the level of supervision, what's the level of complexity. Does the job now fall under computer systems manager or something else? Or is it just a high level business intelligence analyst? We don't know. We'd have to see all of the job duties and make that judgment call.
Whether internship can be done for a H4 person with no payment, I don't know the answer though yet. I know a lot of people do. I haven't seen any problem, but I cannot tell that you can do internships though on H4. I can't tell that.
All right, I think we're out of time for today, everyone. Thank you so much for joining us. We'll be back again next week, Tuesday, 5 o'clock Central Time.
Thank you very much for tuning.